appeal part heard in the matter of Ras Al Khaimah Investment Authority, Azima and others.
Yes, good morning, my Lord. My Lord, we were dealing, before we broke yesterday, with the case of Dechert. I had made the primary point I wanted to make from it, that it is not authority for and does not establish, contrary to my learned friend's case, a blanket, bright line rule that, quote, a litigant is entitled to relitigate fraud even if they have argued it before, if they have new evidence. Even were that an accurate quotation from Lord Sumption, and they've dropped the word decisive, even were it an accurate quotation from Lord Sumption, it's overturned, and so it doesn't bind this court to give it the answer. I've made that point, and I've made the point also that, frankly, if the three key points my learned friend Mr Masefield identified and addressed you on are all made out, that is, if Mr Azima is trying to do by another mechanism precisely that which the Court of Appeal said he should not do and must not do, and there has been no relevant change of circumstances, then the answer is obvious in any event.
Yeah, for what it's worth, just since we've got live note, it appears to be completely scrambled, at least on my screen.
Mine too, my Lord, it's giving me symbols rather than words.
Yes.
I may not be as clear as some advocates, but I'm clearer than it's coming
No,
out.
we're clear of that.
Your Lordships may have felt...
Speaking computer language now, Mr Pilgrim.
Yes.
I can fix that, my lord. It's been sent to the wrong software.
Don't worry, just don't take time.
But your Lordships may have felt that I could have done more to assist the court when faced yesterday with the "that's all very well telling me that Dechert doesn't bind us with the answer, but what is the right test?" question.
Yeah.
And let's see if I can help by saying this. Lord Carr and Lord Sumption have different views about what the position should be when a party wishes to raise an allegation of fraud to seek to set aside a judgment, and that allegation had been raised before at the original hearing. Lord Sumption, in characteristically clear and trenchant terms, suggests a nice bright line. One can always bring fresh claim so long as one has decisive new evidence, and the fraud and materiality conditions will be sufficient to keep everything within acceptable limits. Now, as to that, firstly, that begs the question as to what decisive is in these circumstances. And maybe in trying to answer that question, one re-imports all the uncertainties that Lord Sumption's nice clear test seeks to avoid. But in any event, I do not accept his proposal can be right. I'll give you two reasons for that. First, for the reason that troubled Lord Carr, and indeed Lord Briggs. That is to say, in the scenario in which the fraud in question was raised at the first trial, but the reason that it is now being raised again with new evidence is because, consciously, deliberately and advisedly, the party in question decided not to investigate further at the original trial. And I say Lord Sumption's bright line doesn't accommodate that scenario. It also doesn't, I say, accommodate the scenario in which the first court says in its judgment, in effect, come what may, even if further evidence comes out when these points are investigated further, this judgment should still not be reopened. Much closer to our case, we say. So I would respectfully submit Lord Sumption's bright line doesn't accommodate either of those scenarios.
So what's the second one?
Well, if the court, the first court, in its judgment says, in effect, come what may, even if further evidence comes out on this point, on further investigation, you're still not entitled to reopen this judgment. I.e., if the first court has accommodated or contemplated the scenario.
Well, that's, you say, the facts of this case.
It is, but I'm, for present purposes, trying to assess, can I accept, should this court accept Lord Sumption's clear, bright line?
Well, he may just not have focused on this possibility.
I respectfully agree with that.
His analysis would allow for this possibility being dealt with effectively as an exception to what he...
It might well, or it might say it's not, in that circumstance, the new evidence is not decisive because it was contemplated by the first court that there might be new evidence, so it's not decisive. So I agree with you, it can be fitted within it. It can be fitted within it.
I mean, if we were in a situation where neither the fraud nor the materiality condition could be said to be satisfied, then on the basis of what the Court of Appeal say first time round, these this counterclaim would undoubtedly be abusive.
But we
Never mind what TACOR may or may not have said, because this particular scenario wasn't addressed by TACOR.
Indeed, that's certainly right. I mean, we wouldn't be in this scenario for another reason, that because Mr Azima needed permission, because he was bringing the claim into a new claim, we'd never have got here in any event.
No.
But you're right, man. But what I was going to say, I would accept Lord Carr's analysis if it had been phrased slightly differently. If he'd said, you know, in these scenarios, it may be appropriate to, or justice may require, but the problem is he uses the word discretion when all the abuse authorities tell us that analysis of abusive process is not a discretionary analysis. It may be a broad merits-based jurisdiction, but it's a multifactorial judgment, not a discretion, strictly speaking. So I would respectfully suggest that when one is faced with the question of the relitigation of a fraud claim, one is not in the sphere of clear answers or bright lines. One is in the sphere, as Lord Carr recognises, of it depends. And that determination of the it depends question is better categorised as a multifactorial assessment in accordance with the established abuse authorities than a discretion in the strict sense. Now, I started out saying it may assist the court, it may not have assisted the court, but that is my attempt to propose a way through on this point.
Thank you.
My lords, with that, Koshi, which was the other matter I needed to address.
Yes.
We have in bundles both in first instance Mr Justice Khaimah and the Court of Appeals judgments. But can I start it in this way and say, why is it relevant first? It's relevant, we say, because it is an example of a case that is close, or a lot closer, to the present case. There you have a party that had given evidence in support of an interlocutory application which it said it did not believe and knew to be untrue, and the fact that that was the case had come to light at the substantive trial and been shown in the judge's judgment at trial. And so, against that background, it was a case in which a party raised, in the context of an appeal, an argument to the effect that the previous interlocutory order had been procured by fraud, was unsuccessful in the appeal, and the order in question was not set aside. The party then commenced fresh proceedings to set aside the order in question on the basis that it was procured by fraud, relying on the same fraud case he had raised before, and that later case to set aside the order in question on the basis that it had been procured by fraud, notwithstanding that it involved an allegation of fraud which prima facie had good prospects of success given the findings of the judge at trial, was held to an amount to an abusive process and struck out, and that conclusion was upheld by the Court of Appeal. So it is a scenario, we say, much closer to ours, and therefore is of relevance to the present case, and it gives at least some guidance as to the approach to be adopted in a case like the present. Now, Mr Azima contends, and the judge found, that it can be distinguished on two grounds. One, that Koshi involved an election on the part of, that the Koshi case involved an election on the part of Mr Koshi, and there was no comparable election by Mr Azima in this case. And two, that in Koshi, Mr Koshi did not have new evidence when he brought his claim to set aside on the basis that the order in question had been procured by fraud, whereas Mr Azima does have fresh evidence, and that is said to be a relevant distinguishing factor. So those are the two reasons on which, at Mr Pluman's urging, the judge distinguished Koshi. So before we deal with those two specific arguments, let's look at the judgment itself, and we have it in the authorities bundle, MAAB tab 6. And we can start, for these purposes, at page 24, where Lady Justice Arden starts her conclusions. Now, it is a judgment of the court. Lady Justice Arden gives the judgment. Lord Justice Ward and Lady Justice Smith both agree. So Lady Justice Arden's judgment is the sole substantive judgment. 33 to 36 are important and set the groundwork. So 33. If Mr Koshy's allegations in the new action have substance, they clearly raise an important matter. Firstly, he alleges that a High Court judge was misled on a basic point that led the court into making an order for costs. In other words, he makes allegations about the integrity of the justice system, and there cannot be any doubt but that it is of the utmost importance that the administration of justice should not be undermined by misinformation provided by one party. Secondly, the costs order made by Harman J was in respect of a 12-day hearing involving several parties. Inevitably, the amount of costs would be very substantial. So, these are important allegations with real consequences. 34. On the other hand, the issue is not now simply whether the allegation in the new action has substance, but whether Mr Koshy has already had ample opportunity to have those allegations made the subject of judicial determination. Even though the allegations which Mr Koshy raises are of such seriousness and importance, nonetheless the justice system is not bound to provide more than one opportunity to run these issues. That is because the courts have to strike a fair balance between the interests of Mr Koshy on the one hand and of the other parties and the general interest on the other. That fair balance, in my judgment, is struck once Mr Koshy has had one effective opportunity to put his case. 35, she identifies that the judge was very well placed to deal with this. And then 36, he says, in my judgment, the appeal falls to be dismissed on the following 3 grounds. 1, Mr Koshy had voluntarily accepted. If this court determined his case on the limited basis on which he then chose to put it, he would not bring any further proceedings. And in light of 2 and 3 below, it is too late for Mr Koshy to go back on that acceptance. And 2, in any event, this court dealt with the case put by Mr Koshy on appeal on its merits, and he cannot therefore bring another claim to set aside the costs order of Harman J. And 3, even if I am wrong on 2, it is an abusive process to start a new action. That is the end of the matter, and now turn to amplify those grounds. So the court sets up 3 reasons why the appeal succeeds, and then analyses them in turn. And ground 1, as one can see from the heading, is dismissing the appeal on the basis that Mr Koshy had voluntarily accepted that if this court determined his case on a limited basis, then he would not bring any further proceedings. And that is what is referred to as the election, though an analysis of that is in one sense it's not a true election, but it's a voluntary acceptance. Lady Justice Arden analyses that through to 44, where she reaches the conclusion, she says it's a difficult one, but on balance, that there was an election in that sense, a voluntary acceptance by Mr Koshy's counsel, that if he proceeded on a certain basis, that would preclude him from coming back on any other basis. Ground 2, however, is then an in any event ground. It's one that arises in any event. And that is that the court dealt with the case put by Mr Koshy on appeal on its merits. And for that purpose, Lady Justice Arden seeks to analyse what was the case that was being put. And one can see it perhaps most simply, one goes ahead to paragraph 50, on page 30, where she defines what was the case. Paragraph 50, the issue which Mr Koshy wanted this court to decide was whether, purely on the basis of the 2 paragraphs of the judgment of Mr Justice Khaimah, the costs order of Harman was wrongly made. Having identified what was the issue, that issue, she concludes, has been heard on its merits.
Sorry, which paragraph you're reading from?
Beginning of paragraph 50.
Okay.
Apologies. So is that
Yeah.
the red first sentence? The court answered that question by saying that the approach was oversimplistic. Beginning of paragraph 51, since, as I have said, the issue which this court had been asked to determine is whether the 2 paragraphs of the judgment showed of themselves that the order of Harman J had been obtained by misrepresentation and should be set aside, and since this court has rejected that consideration, Mr Koshy's case had, in my judgment, been dealt with on its merits. Beginning of 52, same point, Mr Koshy wanted this court to adjudicate on his claim. This court held that claim failed for lack of evidence. The judgment was final and on the merits of the claim. So having analysed what was the claim, Lady Justice Arden concludes that it had been determined on its merits. But then her ground 3...
Just before you go
Yes.
further, she says in 51 he hadn't asked the court to take into account the circumstances of the case when it was before Mr Justice Harman. If he'd done so, he needed to start a fresh action. Is that because the Court of Appeal wouldn't be in a position to deal with a dispute as to the facts?
Exactly that. Exactly that. I appreciate that I had to jump straight into the Court of Appeal. But if it would assist, we can go back through the facts.
I suppose one would put a gloss on that by saying, in the light of the first decision of the Court of Appeal in the present case, either start a fresh action or ask the Court of Appeal to remit it to a new judge.
Indeed, I'm having looked at the authority, I'm trying to apply it to our case and see how it lines up with our case. I'll come to exactly that point. Ground 3, Lady Justice Arden's judgment for dismissing the appeal is, even if I am wrong on 2, it's still an abusive process to start a new action. And the premise of this argument is that the Court of Appeal, the court first time round, Justice Rana, did not deal with the merits of Mr Koshy's contention. It didn't dismiss the issue he was bringing on its merits. It dismissed it on procedural grounds only, such that he has not had a decision on the merits. Nonetheless, Lady Justice Arden considers it would be an abusive process. And she does that 54 by starting with Henderson and Henderson, making the point that the court can stay or dismiss proceedings if it is satisfied that they involve an abusive process, even though the claim being brought is not the same one on which there has already been adjudication. That leads to the long quotation from Henderson and Henderson. At 55, she assumes for these purposes that there hasn't been a waiver by Mr Koshy, so there's not been an acquiescence or a waiver. So that's essentially the same election point. He's not given up a right. But nonetheless, paragraph 56, he did make a fully informed and free decision to carry on with the appeal, advised by experienced counsel. Court gave time to take instructions. And against that background, 57, she asked herself, had the judge directed himself to the need to form a broad merits-based judgment, which he didn't, because the judge decided it purely on the election point at the first instance. He would have needed to take into account all the public and private interests involved and the relevant facts as to whether Mr Koshy was abusing the process of the court by seeking to raise before it the very issue which could have been remitted to a judge of the Chancery Division. And let's pause there. The Court of Appeal first time around with Mr Koshy said to Mr Koshy, either you can proceed now on the limited factual basis, or, given we will need to explore the facts, if you want to go on something wider than the limited factual basis, the 2-paragraph of Reimer's judgment, we'll have to remit this to a judge to have a factual investigation. And for her purpose, she's saying he was seeking to raise the very issue that he could have raised in that remitted trial had he chosen to take up that remitted trial, which he did not. So in the 57, she sets out a series of factors to form part of the broad merits-based judgment, which are in favour of Mr Koshy. Clear public interest in investigating misleading of the court, etc. So he has 5 numbered factors, all of which operate in favour of Mr Koshy. In 58, she says, obviously there were factors against reopening this case. Those were in favour of Mr Koshy, what are against? And the most important part of that is about halfway through her paragraph 58, starting more fundamentally, Mr Koshy has already had at least one opportunity to have his claim fully ventilated in a court of law. He chose to have an adjudication of his claim on a limited basis. I would assume in his favour that he made this choice on the basis that the court would determine his claim on its merits. However, on his request for clarification, this court made clear that it might determine the matter against him on procedural grounds. The procedural grounds were that he had failed to substantiate his claim and should have used some other procedure. Mr Koshy had been alerted to the potential difficulties in his appeal. There is a well-recognised public interest in the finality of litigation. It would moreover be unfair on DEG, the party, to allow him to have another opportunity or to make assumptions in Mr Koshy's favour which are not supported by evidence. A new action would subject DEG to a loss of management time and the expenditure and cost which it might not recoup, even if it were fully successful. So, 59, then there is a balancing act, balancing the factors on either side. And at the very end of 59, last sentence, in my judgment, the factors mentioned in the preceding paragraph, and in particular, the factor that Mr Khaimah has already had the opportunity to have an adjudication of the issues in the new action, which he rejected despite the clear warnings given by the court, outweigh the factors which weigh in his favour. So having conducted the balancing act to work out whether this is abusive or not, the most important factor in that instance was the fact that he has had the opportunity to advance the case. He's had the opportunity to set out his allegations. So, let's go back to the arguments and the points of distinction identified by Mr Pluman and accepted by Mr Justice Michael Green. First, the election point. The point against me is that Khaimah involved an election on the part of Mr Khaimah, and there was no comparable election by Mr Azima in this case. The first point is this. The fact that Mr Khaimah made an election was not the sole ground on which the Court of Appeal decided the case. On the contrary, there were expressly 3 grounds on which it was decided, the latter 2 of which did not rely on, or not based on, the making of an election. It was those grounds which the appellants relied on. So the fact that Mr Azima did not make a comparable election, if that be right, is neither here nor there, because it does not address the analysis which proceeds not premised on him having made an election, Lady Justice Arden's points 2 and 3, which he makes in any event. So I say it's not a relevant distinguishing factor. But let's look at how it's put in the judgment by the judge. That's core bundle, tab 10, page 27. It starts at paragraph 108. And in 108, the learned judge identifies that the additional defendants relied on Khaimah. 109, he sets out the relevant key paragraph of Mr Justice Reimer's judgment. Paragraph 110 then proceeds to the Court of Appeal, picking up paragraphs 33 and 34 that we have just looked at. And then in the next paragraph, 111, going further, observes that Arden LJ went further still and picks up paragraphs 58 and 59 that we have just looked at. Paragraph 112, he identifies the points Mr Pluman advanced, and those are still the points he advances as paragraphs 37.5 and 37.6 of his appeal skeleton. 113 says, I think the new evidence is a distinguishing feature, and I'll come back to that point. I'll just finish with the election point first. And then 114 is, I also question whether the election point is properly levelled at Mr Azima, and he analyses that through 114 through to 120. And to address that, let's just consider what the position was here. As the judge recorded, Mr Azima had 2 options, as you addressed with Mr Macefield. Given his position was that a massive fraud had been perpetrated on the court, he had 2 alternative procedural avenues open to him in accordance with Dale and Bangor. He could, and Dale and Bangor is quoted by the judge in paragraph 115 of his judgment. We've got the quotations there if you go over the page, the top of page 30. But he could, per paragraph 39 of Dale and Bangor quoted by the judge there, he could bring a new action to set aside the judgment already obtained on the basis that it was obtained by fraud. Alternatively, per paragraph 41 of Dale and Bangor, he could appeal the original order, alleging that the judgment upon which it is based was procured by fraud. A retrial will be ordered where the fraud is admitted or incontrovertible. Where it is neither admitted nor incontrovertible, a Noble and Owens order is sought by which the issue of fraud is remitted to the court below and decided within the same proceedings. Now, Mr Azima, fully advised, decided to raise the allegation within his appeal. Within that appeal, it was put to him that he could proceed at first instance in fresh proceedings, or he could seek a Noble and Owens order. RAKIA, through its counsel, as you've seen, my lord, with Mr Masefield, sought to persuade the Court of Appeal to leave it well alone and justly Mr Azima to start his fresh proceedings. Mr Azima, however, argued forcefully against that. He sought to persuade the Court of Appeal to make a Noble and Owens order and to remit the whole proceedings to be reheard. So in that sense, he did not make a choice like Mr Koshy. On the contrary, he didn't just choose, he argued for one alternative and invited the court to determine the point which of these alternatives should be pursued. And the court did determine that point. The court did choose. Now that's obviously not an election in the same sense as Mr Koshy's position, but we say it is at least as strong a position. Mr Azima's problem is that the Court of Appeal only partially accepted his submission. It accepted the submission not to leave it well alone and let him start afresh. It acceded, for the reasons submitted by Mr Azima, to the request to remit within the existing proceedings. Unfortunately for him, however, he decided only to remit the hacking counterclaim and not the whole proceedings. Now, at that point, Mr Azima's problem was the Court of Appeal order. He had got in part what he wanted, but only in part. And he had two options then, and only two options, because the third option of simply ignoring what the Court of Appeal have said and starting afresh was not, we say, an option that was properly open to him. His two options were to seek to appeal to the Supreme Court to get the order overturned, which he tried, bringing new evidence to bear for those purposes.
Sorry, you said he had two options.
Yes, his two options are seek to appeal the order to the Court of Appeal and seek to persuade the Court of Appeal to reopen the appeal.
Oh, yeah, sorry.
Because his problem, I say at that stage, was the Court of Appeal's order. He tried to appeal to the Supreme Court, my learned friend Mr Masefield has showed you that, and was unsuccessful. Alternatively, he could seek to persuade the Court of Appeal to reopen its order, and the procedure to do that is found in 5230, Rule 5230. Now,
Well,
let me.
no, I because you know, at the risk of showing one's hand, as it were, the thing which has always troubled me about the judge's judgment is that the judge has effectively overruled an order of this court without being a member of this court. No disrespect to the judge, but it's a slightly odd scenario. Having said that, Mr Justice David Steele did overrule the order of the House of Lords in the Kuwait Airways number 11 or whatever it was.
He absolutely
I think
did.
that was at the behest of...
It was, exactly. That's, your Lordship has the difference.
The behest of their Lordships.
Their Lordships remitted the
They
very
remitted
question.
on the basis that if he decided it in a certain way,
Exactly.
it would be...
Exactly.
just as... well, no, not just as, actually, because the hacking counterclaim, they didn't deal with that. Yeah, okay.
But your Lordship has, that's exactly,
Okay.
the point. But let me just complete this. So we say his alternative was 5230. If it's wanted, it's page 1933 of the White Book, but I'm not sure that's needed. Now, I accept that's got a high bar. It requires, and the Court of Appeal will not do it, will not reopen a final appeal unless it is necessary to do so in order to avoid real injustice, and the circumstances are exceptional and make it appropriate to reopen the appeal. So it is a high bar, I recognise that. But if he considered he had new evidence which materially changed the position, which is precisely what he contends now, then that is the route he should have taken. Now below, we had a debate about the third limb of the test in 5230, which is there is no alternative effective remedy. And all three of those limbs need to be made out before a Court of Appeal will reopen an appeal. The debate was this. Mr Azima said, I did have an alternative remedy because I had an entitlement to commence fresh proceedings. To which the response was, well, whilst you had a theoretical entitlement to commence fresh proceedings, actually doing so in the circumstances of your case was abusive and so liable to be struck out, with the result that you did not actually have an effective remedy, since those fresh proceedings would be struck out as abusive. Now, I was not proposing to look at the authorities considered below on that point. A, because we've not put them in the bundle. B, because I say actually the answer is clear on the face of the rule when you think about it. The rule says effective remedy rather than entitlement to pursue another avenue or words to that effect, because it wants you to consider whether that remedy is actually effective in the circumstances of the case. And C, the third reason I'm not going to go to those authorities is the point has become somewhat arid in any event. And I say that because Mr Azima has made clear in his appeal skeleton, his respondent skeleton, it's footnote 8 on page 22, that if this court holds that it is abusive for him to commence fresh proceedings or pursue his counterclaim, then what he will do, on the basis that he does not actually have any alternative remedy, is apply to reopen the previous Court of Appeal, the previous appeal under Rule 5230. So it's become arid because he said, if actually I don't have an effective remedy, then I will take that route. But that, we say...
then of course the critical question is whether you should have done that first.
Well, yes, I don't want to preempt those. If we arrive in that scenario, we may be then having further arguments. For present purpose, I think it suffices for me to say I don't need to get into how 5230 operates because at that point's become somewhat arid.
Mr. Pilbara, imagine a different scenario.
Yes.
Imagine that none of what we're now dealing with had happened, and the remitted hacking counterclaim went to trial as envisaged by the Court of Appeal and was concluded. And for the sake of argument, imagine that nothing changed. It failed just as it had failed before, just for purposes of an assumption. And
Yes.
we're now 2 years after all. That's all now ancient history. And then what is now being put forward as new material emerges, and for the purpose of this analysis, assume it can be said that it wasn't available before. Why would bringing a fresh action to set aside the fraud trial in those circumstances be contrary to the Court of Appeal's order?
But for this hypothesis, the Court of Appeal first time round has made the order that it did make.
Yes, exactly.
So it has said
the Court of Appeal makes the order.
it is remitted
The
only.
remitted hacking trial that's been remitted by the Court of Appeal order takes place,
Yes.
and nothing changes. It's all finished. And there's an appeal, it fails, whatever, it's over. And then some period after that, Mr Azima comes along and says, well, I've got all this new evidence to prove that the original fraud trial was procured by fraud, which has nothing to do with, he says, the points that were being made. Why would that be? It might be an abuse or not, but why would it be contrary to the Court of Appeal's order?
Well, let me take that in stages. I say it would be contrary to the Court of Appeal's order because the Court of Appeal considered a submission that the original judgment had been procured by fraud and reached a conclusion that the way it was going to determine this situation, which I described yesterday as a plague on both your houses order, is I'll remit the hacking counterclaim, but we're not going to disturb the substantive judgment, save that I will allow you to revisit interest and costs. And insofar as Mr Azima is down the line coming to say, I would still now, in the future, like to do that which I failed to persuade the Court of Appeal to allow me to do, that is prima facie abusive because he's having a second go at or collaterally attacking the Court of Appeal's order. But on your lordship's on your lordship's analysis, and what may change is he said, well, he comes back in the future and says, there is something else out there that proves this to be fraudulent. The oddity of this case is that in determining the hacking counterclaim, we will be addressing the factual allegations which support the suggestion that the first judgment was procured by fraud, because the fraud that is said to have taken place in the first judgment is the lying about the hacking and the cover-up of the hacking. And in assessing the hacking counterclaim, we're going to have to consider whether actually RAKIA were responsible for the hacking, and that will necessarily lead to the conclusion that the witnesses either did or didn't lie. So the oddity of this case is that in your lordship scenario in 2 years' time when Mr Azima is coming back saying, now I'd like to set aside for fraud, it could only be something completely new from the allegations that have been covered in the hacking counterclaim, which is the scenario my friend Mr Macefield accepted. If there is something qualitatively different, a completely different fraud on the court, that has not been ruled out. What we're complaining about is Mr Azima went to the Court of Appeal, said this is the fraud that has been perpetrated on this court. He put it broad, he put it high, and the Court of Appeal took a view on that. And it's his attempts to have another go at that case that we object to. Thank you. So I was just dealing with the election point. First, we say election is not a relevant distinguishing factor because it was not necessary to the reasoning of Cauchy. Second, we say that what Mr Azima did, which was not make a unilateral choice himself, but invite the court to decide the point, it doesn't put him in any better position than if he'd made a unilateral choice. And thirdly, I say this, when one considers the way the judge treated this point, in paragraphs 114 to 120, and I invite you to go back and look at those afterwards. He sought to say, Mr Azima has not made a relevant election because he had been seeking to persuade the court to remit the whole case and had not been seeking to persuade the court to remit only the hacking counterclaim, which is what the court ultimately did. So the court didn't do what he asked, Mr Lord asked it to do, and it cannot be said, therefore, that he elected for that option. But with respect, that makes our point for us. It makes the point that Mr Azima was seeking to have the whole claim remitted on the basis of the massive fraud, which is precisely our point, and precisely why we say he is now seeking to have a second go at achieving that same aim. His problem was not that he chose the outcome that he got, but that he argued for a particular outcome and got a lesser one. And with respect, the point the judge makes does not, as he considered, work against a finding of abuse, it works in favour of it. Finally, the distinguishing point being the no new evidence point. Now, the judge considered this was a relevant distinguishing factor. Paragraph 130 of the judgment, we saw that briefly. And for what it matters, for what it's worth, I say he was wrong to do so. Whilst he is right that Mr Cauchy was not bringing his fresh action on the basis of any new evidence, I say he is not right that this was a relevant point in the Court of Appeal's analysis in Cauchy. What the Court of Appeal concluded was that, this is paragraph 43, and I've read it to you already, so I'll just repeat it now. The fair balance between the interests of Mr Cauchy on the one hand and the interests of the other parties and the general interest on the other was that Mr Cauchy has one effective opportunity to put his case. Once he had had that, it did not matter, see paragraphs 58 and 59 of Cauchy, if he could come back and put the case on a fuller evidential basis. He had had his opportunity and had proceeded on the basis then available to him. He had put his case, and that case had been rejected. That was his one effective opportunity to put it, and justice did not require him to be given a second. And we say the same applies to Mr Azima.
Just pausing
Yes.
there. Supposing there had been a lot of new evidence, he wouldn't have had the opportunity to put that case before. He'd have had an opportunity to put the argument in a bare sense, but it would have been a different case with more evidence.
But, that's perhaps when one gets arguing about what was meant by case for these purposes. But yes, I'm not going to stray from the concession Mr Masefield essentially makes, which is if there's a whole new evidence puts a whole new light on it, then that changes the situation. It does depend on analysing what is the case that was put before and does the evidence make any difference. And when it comes down to it here, what does it amount to in this case? Of course, Mr Azima has more evidence in the sense he has further documents to support the same case. The question is, has he had the opportunity to put his case? We say it's the same argument. And two, does that new evidence, the fact he now has more documents, make any difference? We say no, because they're supporting the same case, and the Court of Appeal, when it considered the broad and high case that he advanced before it, made assumptions in his favour that you can make out that case and still reach the conclusion it did.
So suppose, which I know you say is not the case at all, I'm not sure anybody says is the case, there had been an absolute smoking gun in this new documentation. There had been a memo from the ruler explaining that he entirely understood that Mr Azima had acted grossly improperly before, but he thought it would be a good idea to get Mr Azima to enter into the settlement agreement so that complaint could then be made about it. You see what I mean? Something absolutely a smoking gun. It couldn't then be right, could it, to say, look, there was an argument vaguely, along the same lines before, but lacking the evidence. That's that.
I accept that, my lord, to this extent, and that really gets back to the heart of this, which is it's very difficult to put bright lines down in a situation like this. All the abuse of process authorities tell us that it is nuanced, factually intensive, balancing act, multifactorial judgment. And I entirely accept that one takes one to one extreme, and we're arguing then in smoking gun territory. Is there new evidence that is materially changing the situation? Well, in smoking gun territory, one probably is recognising that there is. Equally, at the other end, you have Mr Koshi's situation, which is no new evidence at all, and just wish to have another go, please. And we obviously are somewhere between that.
But it's a nuanced scenario, isn't it? Because if you just look at the, as it were, sort of simple example where there's a trial of the fraud issue, in which Mr Azima fails to establish that there's been a fraud on the court. That is subject to an appeal, which also fails. 3 years later, more material emerges, which he argues would have made all the difference. Whether or not the court is prepared to allow that fresh material to go forward to effectively a retrial will depend upon a number of factors, won't it? It will depend upon how the new material came about, whether it's material that he could, for example, have with reasonable diligence, well, maybe not with reasonable diligence, but the material that he could have obtained earlier, whose fault it is that the material hasn't been brought forward earlier, etc., etc.
Indeed,
you could not say, under no circumstances whatsoever, could he reopen that first trial if a whole load of critical new evidence emerged.
I appreciate that, my lord. Let me say this: one could follow that conclusion through and think, well, this is working against you, Mr Pilbrow, because the more I ascertain that this is a careful, nuanced, difficult judgment, the more deference I should give to the judge's judgment in this case, which is against you, Mr Pilbrow. So actually you're talking yourself out of your appeal. But I say with flex, no. And the reason for that is the critical failing of the judge is to understand properly what the Court of Appeal decided last time, and therefore what the effect of its judgment was. He reaches a conclusion the Court of Appeal did not intend in its judgment to say, which it set in terms, whatever the outcome of the hacking claim, this must stand. He took the Court of Appeal to be meaning something less than that. And that critical failing means that this court must look again at this multifactorial matter.
And the slight oddity there is, you're not suggesting, whatever the Court of Appeal in strict terms may have said, you're not suggesting that it should be taken to be excluded forever the possibility of a reopening. You say, well, if there were a smoking gun, then perhaps it could be right to have a reopening. So was the judge in substance, even on your case, wrong to take the Court of Appeal that way, because it didn't preclude reopening under all circumstances?
That's fair. It doesn't preclude reopening under all circumstances, because we accept if he brings forward a materially different fraud, the most extreme example, but it's clearly not been closed out in that situation. But he says in terms that the court didn't anticipate the scenario we have now and can't be taken to have closed out that scenario. And we say to that two things really. One, when one thinks about what the Court of Appeal meant when it said, irrespective of the outcome of a hacking claim, this must stand, we submit that that must mean, well, the hacking claim is pursued, it is successful, and in that success, evidence in support of it, further evidence in support of it may well come out so that it is successful. That notwithstanding, it must stand. And we say, properly understood, that does preclude the attack such as the one we have now, even if not any conceivable attack that one could conceptualize. And in that connection, I do say this. I mean, Mr. Macefield dealt with, you know, the breadth of the Court of Appeal's assumptions and why the Court of Appeal was still, in any event, right to characterise the alleged fraud as collateral, all those points. But in this connection, the point I want to make is this. Mr. Azima says the Court of Appeal didn't foresee precisely that which is eventuated now. And I say that is precisely the sort of point that the principle of finality is intended to cover. It is not necessary that the court somehow preempted or foresaw this precise scenario. I am, of course, in awe of the capabilities and talents of the Court of Appeal, but seeing into the future does not need to be one of them. The court could not have foreseen the precise scenario that is eventuated, but it did engage with the allegations being put at the time, which were broad enough and high enough to cover, we say, all the evidence that is now relied on, and reached the conclusion in those circumstances, plague on all your houses, this is how I'm dividing this up, it must stand irrespective of the outcome of the hacking counterclaim. And as Lord Wilberforce told us in the anterior period case, finality tells us that at some point the book has to be closed. And we say that moment has come for the case that Mr. Azima advances, taking my Lord Justice Newey's point that it may not have come in respect of any conceptual case which might exist out there, but that which we're facing, we say that time has come for that case. And in that sense, I say Mr. Azima should be held to the consequences of deliberately, consciously, advisedly, running such a wide-ranging and sweeping fraud case through these proceedings, and most importantly, before the Court of Appeal and the Supreme Court. He chose to put broad, all-encompassing case, invited the court to engage with that. It did engage with it. It made assumptions in his favour. It just did not produce the result he wanted. But he should now be made to live with that result. My Lords, unless I can assist any further, I think I have already extended what was supposed to be my allocation.
No, thank you. Thank you very much, Mr. Pilgrim.
Well, I see the time. Do you want to begin?
Carry
now?
on, Mr. White.
Yes, certainly.
Till about 11:45. Really.
I'm conscious of being very much at the end of the batting order, and you've heard a lot of submissions on behalf of the appellants, and I should be brief. My Lord, in many abuse of process cases, the re-litigation which occurs is not anticipated by the anterior court. So when Mr. Justice Bridge, as he then was, gave his judgment on the voir dire in Hunter, he didn't have in mind that there might be a civil claim raising allegations against the prison officers and police in question. What makes this case unusual is that the decision of the Court of Appeal, the anterior court for present purposes, expressly anticipated and indeed directed re-litigation. But it was at pains, we submit, to fix the boundaries of the permitted re-litigation, ruling on what could and couldn't be reopened by Mr. Azima. I mean, that's why, as Mr. Macefield submitted, the key question, and I apprehend we're all agreed on this, is the meaning and effect of the Court of Appeal decision. But it may also mean, this anticipation of re-litigation, that some of the multiple factors that might in an ordinary case go into the multifactorial evaluative assessment are of limited significance case, the real focus is on the limits of the permitted, indeed directed, relitigation. My Lord, we, for that reason, adopt the submissions made by Mr. Masefield. We also adopt Mr. Pilbrow's submissions on the law and in particular the judge's treatment of Koshi, and I'll just seek to make a small number of supporting submissions. Well, the first issue I wanted to just say a little more about is the question of what points were and were not taken by Mr. Azima in his appeal to the Court of Appeal. Beginning first with what was not part of his appeal, Mr. Masefield showed you yesterday the critical exchange between Lord Justice Mayles and Lord Justice Lewison and Mr. Lord on day 2, pages 147 to 8. We needn't turn it back up. It's the passage ending with the reference to the Lucas direction, in which Mr. Lord accepts that it's no part of his appeal to challenge the findings of fraudulent conduct on his part. And that, as Mr. Masefield explained, is a very important part of the, or very important foundation for the approach the Court of Appeal took. What he did challenge, Mr. Azima, and this is something I want to say a little bit about, although he didn't challenge the findings he'd acted fraudulently, made fraudulent representations, he did challenge the findings of reliance. And I know from my Lord's interventions yesterday that there is concern about reliance. My Lord the Chancellor said you were troubled about reliance and thought perhaps that the entire court was. And Lord Justice Newey also made observations about reliance. My Lord, by the time the case was formulated for the Court of Appeal in writing, reliance was very much in issue, and we summarised in our skeleton, I think this is the easiest way to draw the references together, at MACB tab 7, page 4, paragraphs 5A and 5B of our skeleton, the way reliance was addressed in Mr. Azima's Court of Appeal skeleton arguments.
Page 4.
Page 4. So it's tab 7, MACB, tab 7, page 4. This is part of paragraph 5, and we set out at A and B what was said about reliance in the replacement skeleton argument, the appeal skeleton argument, and the supplementary skeleton argument. In support of the appeal in his replacement skeleton argument, he contended the finding that RAKIA relied on the heavy lift investment representation and the good faith representation was wrong and should be set aside, and he's put that forward on various bases.
Yeah.
Including that for the reasons advanced under grounds 1 to 5, that was the challenge to the rejection of his case on hacking, the judge should have found the ruler directed Mr. Page to carry out the hacking and that RAKIA was responsible for the hacking attack. In those circumstances, the only written evidence of the ruler and the evidence of RAKIA's other witnesses that they relied on Mr. Azima's representations cannot be credited. And he amplified the point a little in his supplementary skeleton argument, which my lords will recall was in support of his application to admit new evidence in support of his claim that RAKIA was responsible for the hacking, the phishing evidence and the cyber route evidence. And he said at paragraph 28, alternatively, if the court's not minded to find for itself that RAKIA was responsible, the phishing evidence and the vital CR evidence would show the judge's conclusion on the hacking was plainly unsafe, and that the hacking issue must be remitted along with the ramifications of a finding that RAKIA was responsible, which must include the consequences for RAKIA's own claims. On either basis, the new evidence thus provides strong confirmation of Mr Azima's case on the hacking, with all the consequences that then follow. It bears emphasis that those consequences include implications for RAKIA's own case. If it's found RAKIA had indeed targeted Mr Azima through hacking and disseminating his confidential information, then as set out in the appeal skeleton at 84, this flatly contradicts RAKIA's own claim to have relied on representations that he made. So he squarely put reliance in issue. His case, in essence, was that if RAKIA was responsible for the hacking, this would undermine or taint the Deputy Judge's findings on reliance. My Lord, Mr Maysfield showed you how the case expanded in oral submissions to include, in particular, repeated allegations of a massive and sustained deception of the court by all of RAKIA's witnesses. And the question of reliance and where that fitted in to that case advanced in the Court of Appeal was part of the discussion Mr Maysfield showed you yesterday in the passage culminating in the Lucas direction. And as my Lord the Chancellor observed, the Lucas direction observation appears to have been aimed at Mr Buchannan, because Mr Page and Mr Halabi had been set aside as unreliable witnesses. My Lord, after that reference by Lord Justice Lewison to the Lucas direction, Mr Lord, for Mr Azima, moved fairly rapidly from a wider position on reliance, namely that if RAKIA had hacked, the case on reliance would be undermined, to a narrow point on reliance. I can term it the evidential gap point, which was that although Mr Buchanan had said he relied, the ruler who made the decision hadn't said that. Shortly after the reference to the Lucas direction, that's where Mr Lord starts to emphasise his position on reliance. Now, Lord, as we saw, the Court of Appeal ruled on the narrow point on reliance, the evidential gap point, at paragraphs 71 to 78 of its judgment. I don't think we need to turn that out. We looked at it yesterday. It didn't expressly rule, and this is a point Mr Azima makes in his skeleton argument, on the wider challenge to the finding of reliance. But, my Lord, there is absolutely no basis for suggesting that the Court of Appeal wouldn't have had that wider attack on reliance in mind when considering whether RAKIA's judgment against Mr Azima should be remitted on the basis that it had been obtained by fraud. They wouldn't have forgotten that. It was discussed in particular between Lord Justice Mayles and Mr Azima on the transcripts we've seen. And my Lord, an important aspect of that in our submission is to keep in mind some points about timing. Because the Court of Appeal was alive to the point that if RAKIA had been responsible for the hacking, they would have had in their possession the hacked documents showing what they showed about the heavy lift transaction and Mr Azima's misconduct before, and this is the critical point, before the settlement agreement. And one can see that the Court of Appeal were well aware of that because they mention at paragraphs 15 and 20 sub-Roman 2 the dates of the alleged hacking on which Mr Azima relied. So do you want to turn those up? It's MASB 11, 5 and 6.
Sorry.
So Court of Appeal judgment, my lord. So it's
It's the
tab.
supplementary bundle, isn't it?
Yes, I'm sorry. It's the supplementary bundle, tab 10. I'm sorry, it's tab 11. That's why
Tab 11,
I'm
yeah.
at fault. Yes, tab 11. In fact, I'd written it down correctly and said it wrongly. Page 5. In paragraph 15, when they're giving a sketch of the facts, they refer to a document which Mr. Masefield mentioned yesterday, the view from the window document dating from December 2015. But they note, and it's the last sentence that I draw attention to, Mr. Azima contended that this showed that by this stage, in other words, late December 2015, RAKIA had obtained access to his emails. And the reason I mentioned paragraph 20, little Roman 2 on the next page was in picking out features of Mr. Azima's case. They mention the date when he alleged the hacking had taken place on or around the 14th of October 2015. Now, Lord, even taking into account the wider attack on reliance and recognizing or realizing that the chronology meant that would have placed the hacked materials into RAKIA's hands before the settlement agreement, the Court of Appeal still held that Mr. Azima should not be permitted to reopen the judgment RAKIA had obtained against him on the grounds that it had been procured by fraud. And my lord, we submit that the fact the Court of Appeal didn't expressly address and reject the wider argument on reliance doesn't assist Mr. Azima. A court is not obliged to rule on every submission made. And I've spent much of my career at the bar making submissions that haven't always featured in judgments which followed. If one needs any authority for that, it would make my lord's lives more pressurized still if you had to rule on every submission. But Johnson and Gore Wood has a helpful and pithy statement at page 22. That's MA, the authorities bundle, MAAB, tab 4, page 22, but I don't think we need to turn it up. It couldn't sensibly suggest that the court has to rule on every argument in arriving at its result. But Lord, it's important to see something that happened in the Court of Appeal, which may explain, and probably does, by reference to a transcript extract I'll show you, why the Court of Appeal may not have thought this point was being pressed particularly hard by Mr. Azima. You need to get clear in your minds 3 dates for the purposes of this submission. The first is a date I've already shown you, that Mr. Azima's case on hacking at trial was that the documents had been accessed in October 2015. Second date is the date of the settlement agreement. That is the 2nd of March 2016. The third date is relevant to his new evidence of hacking, which the Court of Appeal admitted. And the important point in chronological terms is that his case on hacking by cyberroute was that it occurred in March 2016 after the settlement agreement had been entered into. My lord, if one needs to make that good, one sees, and I'll just give you the paragraph numbers, one sees that expressly stated in the Court of Appeal's summary of the new evidence at paragraphs 132 and 134. Now, the chronological significance of his shifting case on the facts of the hacking led Mr. Tomlinson to make a submission I want to show you back in the Court of Appeal transcripts at MASB, the supplemental bundle, tab 10, pages 13 to 14.
Sorry,
Tab 10, pages 13 to 14 of the bundle, page 110 first of the manuscript, please.
Okay.
So this is Mr. Tomlinson's reply to the wider point about reliance. And what I wanted to draw attention to is, firstly, page 110 in the manuscript, lines 5 to 11. He's addressing the submission that because RAKIA already had the hacked documents before they entered into the settlement agreement, they couldn't have relied because they already knew what Mr. Azima had done. And Mr. Tomlinson says, in any event, the submission that they knew the true position doesn't work either, because on the latest version of the theory, the hacking theory, the hacking took place after the settlement agreement was entered into. So they can't have known the true position at the time it was signed. But as I say, that point doesn't seem to be very strongly pursued.
I suspect you're going to answer all my queries and what you subsequently say, but while it's my mind, just so I'm clear about it, this seems to be Mr. Tomlinson saying, well, hacking can't affect reliance because it only happens afterwards.
On his new case.
On the new case. But if that's being put to the Court of Appeal, they're not addressing the possibility, or wouldn't have in their minds, that the sort of hacking that's said now to have been revealed could have happened and therefore could have affected reliance.
Well, Mr. Azima's case, as I've sort of shown you, was originally the hacking was in October 2015,
Yes.
and therefore did affect reliance.
Yes.
He didn't drop that case. He simply sought to introduce this new evidence, but the new evidence had a chronological problem for him. It located the hacking after the settlement agreement was signed.
I mean, I quite follow, if it's put to the Court of Appeal, well, there might have been hacking after the date of the settlement agreement. That can't affect reliance for the purposes of the settlement agreement. But might that even be a point against you if there now seems to be evidence that wasn't available before of hacking before the settlement agreement that could have affected reliance?
Well, that remained his case. And the Court of Appeal point out at 134, I think it's 132 or 134, that there's a certain tension between his existing case, which is hacking in October 2015, and his new evidence suggesting hacking in March. But he didn't drop the existing case. What the point Mr. Tomlinson is making, I apprehend, is that because of that tension between the new evidence and the existing case, Mr. Lord wasn't pressing very hard this point about reliance. And I draw that to your attention because it may explain why the Court of Appeal didn't find it necessary to address and determine the wider point on hacking. Not that it wasn't put squarely before them, but there was a reason for a certain amount of soft peddling because of this tension. But my lord, the case that remained Mr. Azima's case was the hacking had occurred before the settlement agreement, and the Court of Appeal were alive to the relevant chronology and to that point, but notwithstanding that, decided he couldn't reopen.
Mr. White, forgive me, I understand the point you're making, but how does it fit with the order the Court of Appeal actually made? Because the Court of Appeal's order, as I read it, doesn't say, for example, that if you showed that the hacking led to evidence which demonstrated actually was pre-reliance and therefore undermined reliance, you can't win that. What it says is that if the counterclaim establishes that the respondent was responsible for the hacking and the dissemination of the data, then it stays struck out. That doesn't address the point you're making at all.
Well, the judge made a point about paragraph 4 of the order, and we've addressed it in our skeleton. We respectfully submit you can't read paragraph 4 in isolation from what was before the Court of Appeal and their extended reasoning. It is on any analysis a summary, rather than a comprehensive distillation of the reasoning of the Court of Appeal. And we submit that the judge only relied rather tentatively on paragraph 4. And we submit, in fact, it doesn't assist. What one needs to do is look at all of the materials we've been looking at. What was Mr Azima's case before the Court of Appeal? What did the Court of Appeal do in response to that case? And paragraph 4 is not a full digestion of the extended reasoning in the judgment. Lord, Mr Tomlinson returns to the point. I'll just give you the second reference. At manuscript page 115, I think we're still in the supplemental bundle tab 10. And there's some discussion between Lord Justice Males and Mr Tomlinson about reliance at the foot of 114 and top of 115, and Mr Tomlinson at 17 on 115 makes his point again. Lord Justice Lewison has asked him about the trap theory in relation to the settlement agreement. Mr Tomlinson says, yes, a theory which now, of course, can't stand with the latest version of the case, because as I said more than once, it's now the case that the hacking took place after the settlement agreement was entered into, so the settlement agreement couldn't have been a ruse. But the judge deals with, when he's going through the various points in support of the hacking case advanced by Mr Azima at the trial, from 310 onwards, he analyses that argument, rejects it. None of that reasoning is challenged as I understand it. And then the same point about soft peddling. In any event, perhaps things have moved on. So Mr Tomlinson is subtly pointing to the tension the Court of Appeal find at paragraphs 132 to 4 and suggesting that the narrower point on reliance has taken prominence because of the chronological difficulty in relation to the wider point. But my lord, we also say this, even if there is a failure by the Court of Appeal in a judgment that had to address a great number of issues to address an argument, in this case about reliance, that doesn't help Mr Azima. It might give rise to an appeal. One's got experience of appeals which assert that the court below didn't deal with a point which it should have done. But Mr Azima tried and failed to appeal. It might also allow the affected party to ask the court to deal with the point. What it doesn't do in our submission is allow the affected party to ignore the court's decision and seek to circumvent it and then say, well, a particular submission wasn't ruled on. We say, when you look at all of the materials in the round, you are driven to the conclusion that the Court of Appeal had in mind the wider challenge to reliance and the chronological complications, but notwithstanding that, didn't feel, or indeed felt firmly, that Mr Azima should not be permitted to reopen the judgment RAKIA had obtained against him. Well, that reliance was the principal point I wanted to touch on. Unless there are any questions arising out of that, shall we have the break now?
May I just express some concern about time, my lord?
Yes.
Malone Friends are well in excess of the agreed timetable.
When were you due to start?
I should, in order to give them 45 minutes before lunch tomorrow, if you do the maths, I should have been on my feet at 11:15, even were we sitting for a full day today, which we are by 15 minutes not.
Right, well, we'll sit at 10 o'clock tomorrow morning if need be.
Thank you.
All right.
Ask you reverse.
It's actually not, I mean, it's not your fault, but there's an agreed timetable here and it's not right. Yes, I was directing it elsewhere, but
I'll try and keep the record.
Yeah, that worked. I had someone, when were they taking us? I've got 2 lights there. He says between 9 and 9:30 last Friday night. How can last Friday night?
It might be the third.
Yeah, don't worry.
Nothing to do with the case.
Trivia.
Something much more important. Right.
Yeah, he meant. I mean, we'll leave this thing, you know, maybe I should.
Yes, I just That's good.
Supreme Court true, but it does. That's what allows you to attack the space.
Maybe first.
All right.
Lord, I didn't mean any disrespect to Mr. Pluman, and we are running in slightly into borrowed time, and so I shall speed up.
Well, we're in borrowed time, but not excessively so.
Not excessively.
It's not in a 3-day appeal.
Well, thank you, my Lord.
We'll find the time one way or another.
I'll proceed accordingly. My Lord, I was addressing what Mr. Azima had challenged in his first appeal to the court, in his appeal to the Court of Appeal, and I've dealt with reliance. The other factual matter he did seek to challenge by way of introducing, by way of an application to introduce new evidence, was one step in the Deputy Judge's reasoning on the conspiracy claim, namely a finding of fact that Mr. Azima had not introduced the purchasers of the hotel. You may have picked up from Mr. Maysfield's references to the judgment yesterday that that finding of fact was based principally on a document that Mr. Azima's assistant, Mr. Adams, had prepared, which said in a formal account of the transaction that by the time Mr. Azima got involved, the purchasers were already negotiating. And that word already, the judge said, fatally undermined the case that Mr. Azima advanced.
Yeah, and he made the point that the evidence that it was a mistake was unconvincing because Mr. Azima would have picked up the point if it was really just wrong.
Absolutely. It had been passed to Mr. Azima for approval and he hadn't changed that. But Lord, I just want to add this point. The evidence Mr. Azima sought to introduce to challenge that finding was much more direct than anything he now has on this point. It was evidence from one of the purchasers saying, I've come forward because I'm concerned, Mr. Azima, it might be the subject of a miscarriage of justice on this issue. I've come forward to tell the truth, and I was introduced by Mr. Azima. But the Court of Appeal rejected the application to admit that evidence, as Mr. Masefield showed you yesterday, on the basis that it wouldn't impact on the main reason for the judge's finding on conspiracy, namely the payment of the bribe. I just want to emphasise that, contrary to the intervention Mr. Pluman made at the end of Mr. Masefield's submissions, this point doesn't go to materiality. It's not an attempt by us to rerun materiality arguments. It goes to whether the Court of Appeal has already ruled that further evidence that Mr. Azima introduced the purchasers wouldn't impact on the conspiracy finding. Well, the next issue I want to just add one small point on is I adopt what Mr. Masefield said about the judge's unduly restrictive interpretation of the Court of Appeal's assumptions made in favour of Mr. Azima. In particular, the attempt by Mr. Pluman to say the Court of Appeal may have just had in mind Page and Halabi. Lord, Mr. Masefield showed you
more in mind from the raising by Lord Justice Lewis of the Lucas direction in argument.
Well, my Lord,
that could only be relevant to Buchanan and not to anybody else.
My Lord, that's absolutely right in my submission. But I just want to add one point to what was said yesterday, which is Mr. Masefield showed you one reference where in Mr. Lord's broad and comprehensive allegations of a fraud on the court, there was a reference to all the witnesses. There's another good reference in support of our position at supplementary bundle tab 10, page 8, manuscript page 42. Just quickly get that on screen, please.
Yeah.
Confusing myself again by that reference here. You were shown part of this yesterday, but not the few lines I just want to draw attention to. This is Mr. Lord.
Wholesale lies by all those witnesses.
Precisely so, my Lord. Top of page 42. Grotesquely unfair to Mr. Azima. Let's assume the hacking dispute wholesale lies by all of those witnesses. Court massively deceived. My Lord, adding that to what you were shown yesterday, the suggestion that the Court of Appeal meant something other than they said, when they said at least some, is not done. My Lord, we make a submission in the skeleton that I'm going to take very briefly, because you have it in writing. We say one error in the judgment, this is a new point not yet touched on, is inappropriate compartmentalisation by the judge of the Court of Appeal's judgment. We say that what the Court of Appeal did structurally is clear in a complicated judgment. There's nevertheless, we respectfully submit a clearly discernible structure, as one would expect. It acknowledged at paragraph 8 that Mr. Azima was seeking remission of the whole judgment, including RAKIA's judgment against him for fraud, on the ground that the whole judgment had been obtained by fraud. It then explained why it wasn't persuaded that RAKIA's judgment against Mr. Azima should be remitted on the grounds that it had been obtained by fraud, but instead should stand. And in large part, the Court of Appeal founded, as Mr. Masefield submitted, on Mr. Azima's lack of challenge to the findings of fraudulent conduct on his part. The Court of Appeal then moved to consider whether the judge's conclusions on the hacking counterclaim should be remitted, and decided they should. But my Lord, we respectfully submit, and it may not greatly affect the outcome of the appeal, where the core question is whether the judge got the right answer on what the Court of Appeal said and its effect. But the judge seems to have become puzzled by what he seemed to see as separate sections of the Court of Appeal's judgment. And I'll just give you the references, because you're going to obviously read the judgment again. At 56, and again at 64 to 69, and finally at 116 and following, the judge appeared concerned about the Court of Appeal's deployment when considering the determination of whether the hacking counterclaim should be remitted, of a point Mr. Lord made to them when seeking remission of the entire judgment, and appeared concerned that that was somehow inappropriate because Mr. Lord's submissions had been in support of remission of the whole, but the Court of Appeal took them into account when deciding to remit part. But my Lord, echoing something Mr. Pilberow has said, that structure in the Court of Appeal judgment doesn't mean the Court of Appeal failed to determine Mr. Lord's case that the entire judgment should be remitted. It simply rejected it in part and accepted it in part. And the submissions Mr. Lord made as to procedure when seeking the remittal of the whole were understandably taken into account by the Court of Appeal when determining to remit part. And by
I can't remember now which paragraph it was of the Court of Appeal judgment the judge was puzzled by.
my Lord, if we just go to the judge's judgment, it's in the
I must confess, when I looked at it myself, I wasn't puzzled.
No, the judge's puzzlement, which clearly troubled him because he comes back to it twice.
Yeah.
It's tab 11. Sorry, I'm confusing myself. My Lord, in the judge's judgment, it's obviously in the call bundle, it's at tab 10. And the judge, first of all, the first time we suggest this concern emerges is at paragraph 56. There's really an introduction to the question of an election or something analogous. He says at the end of 56, however, it must be understood that Mr. Lord's submissions were all predicated on the whole claim, including RAKIA's claims, being remitted for a retrial, at least it being open to the retrial judge to set aside RAKIA's claims if the fraud was proved. His submissions were not directed at the situation where only the hacking counterclaim would be remitted, together with the direction that RAKIA's claims could not under any circumstances be disturbed. But true, but so what? He'd sought the remittal of the whole, but only succeeded in part. And then the judge says at 64,
well, it's the point he makes at
my Lord, if you were looking at for confusion.
67.
67, he says,
I'm a little confused about the reference in 135, the judgment procured by fraud.
My Lord, he makes essentially the point he's made again at 69. You see in the second half. However, from what I've seen in the argument, Mr. Lord was arguing for a remittal of the whole matter, including RAKIA's claims, and he wasn't asked what he'd prefer if it was only the hacking counterclaim that's going to be remitted and RAKIA's judgment on its claims would remain undisturbed. My Lord, as we say, true, but not to the point.
The Court of Appeal here is simply making the point. It's simply looking at that the allegation that the judgment in relation to the hacking counterclaim had been procured by fraud.
Precisely so. Having decided not to.
It would have had to deal with, how do you deal with it? Because if you see what they go on to decide, is they go on to deal with Takar, Dale and Bangor and the alternative approaches that might be adopted. Mr. Lord's submission that the Court of Appeal should decide effectively that the hacking counterclaim should succeed, pretty bold submission, but that's what he seemed to be saying. And they then decline that and say we'll have to remit it.
Yes.
Because we can't decide. That's all this is.
That's all it's about. And the fact that it takes place after deciding not to remit RAKIA's judgment against him It's neither here nor there. Well, my lords have the point. Lord, I adopt what Mr. Pulborough said about distinguishing Cauchy. Can I just add a high-level point about the new evidence grounds for distinguishing Cauchy? And it's this. In one of the passages you were shown yesterday, where Mr. Lord was articulating his broad and all-encompassing fraud on the court submission, it's at Supplementary Bundle tab 8, page 13, but we needn't turn it up. He said this: Mr. Azima already has plenty of evidence of a massive fraud. When the judge introduced the nature of the further evidence now relied on, at paragraph 9 of his judgment, the way he encapsulates the fresh evidence is, in our submission, both accurate and telling. He says at paragraph 9, it is tab 10, page 4, now Mr. Azima wishes to bring an additional counterclaim in which his cause of action is to have the first judgment set aside on the grounds that it was procured by fraud. He has discovered yet more evidence, which he says shows that a pervasive fraud was perpetrated on the court at the original trial by or on behalf of RAKIA. Now, my lord, in our submission, that is a fair description of the position we find ourselves in. Mr. Lord already said there was plenty, there's now yet more. But, my lord, the Court of Appeal's analysis, approach and outcome does not permit a reopening of RAKIA's judgment against Mr. Azima just because there is yet more. Unless I can help further, those are my supplemental submissions.
Thank you, Lord. Thank you, Lordships. Obviously, we rely on all of the points in our skeleton. It doesn't serve anyone for me to read the skeleton to you. What I intend to do is to deal with a range of issues that have come up both in submission and that seem to me to be fundamental to the analysis. As to the way in which I propose to do that, what I would like to do is to start with a brief overview and identifying what the judge in this case, that is His Lordship Mr. Justice Green, found. My friend Mr. Macefield, at least, did not refer to the judgment at all. And then go on to make a few structural points and look at what the scope of this appeal is. I'd then like to deal with the law that is both on setting aside judgments for fraud and on abuse of process, but leaving on one side for that time at least the Cauchy decision. Then most importantly, get into an analysis of what the new evidence is. So the comparison between what the case was at trial on the one hand and before the Court of Appeal the first time around, and what the case is now, and deal with some of the underlying material in that respect. And against that background, then turn to the Court of Appeal judgment and its proper analysis. Lastly, save for the conclusion, then deal with the decision in Cauchy, which we do really say is entirely different to this case, but I'll deal with that at the end and then make some concluding submissions. Having said that's what I want to do, I do want to pick up right at the outset a concern expressed by my Lord the Chancellor this morning as to the potential oddity that this challenge was brought before the High Court, and yet there lay behind what was being attacked, a Court of Appeal decision. Noting, though, that that is what had happened in the Kuwait Airways decision, in that litigation. The first point we make about that is, it is what happened in Kuwait Airways, not just because the House of Lords, maybe the Supreme Court, the House of Lords of the Supreme Court, said that was what should happen, but because it said it was the right thing, it was the right way for it to happen. And why is that? It is fundamentally because the inquiry into the procurement by fraud, judgment procured by fraud, is in many cases one which is too factually complex, too fact heavy, to be dealt with at appellate level, be it in the Court of Appeal or higher. And therefore, the correct process is you go down to the judgment from which it all started and demonstrate that that judgment was obtained by fraud. And that then has consequences for such appellate judgments as may lie above it. Of course, that leaves on one side what my Lord the Chancellor has identified as the key question, which is what the Court of Appeal in this case intended to do, which is a separate question which I will come to.
Yeah.
But so as to the procedure and as to the attack at High Court level, ultimately on a Court of Appeal judgment, we say it's the correct approach. Those points are made in, to some degree, in the Takar decision. They are made in Jones, Coe and Beard. They are made in Flower and Lloyd. The old rule was indeed that you had to go down to start again at the bottom. There's an associated point made by my learned friend Mr Pilbrow this morning relating to the potential application of CPR 5230, the exceptional remedy in the Court of Appeal. And our first point on that is one of the issues which His Lordship Mr Justice Green decided and which is not appealed. His Lordship Mr Justice Green did decide that there was another effective remedy, and that was not appealed, and that is how we are here. It's simply not open to them to argue it at this stage. And in that context, in the context of Mr Pilbrow raising that argument, well, Justice Birss asked a question at page 22 of today's transcript, saying, well, why, in the event, does all of this find purchase in circumstances where what is happening is there is new evidence with which the Court of Appeal was not dealing with? And my learned friend Mr Pilbrow's answer at page 24 was to say, well, it is because the lying that is said to have taken place, the dishonesty that is said to have taken place in the first judgment, is the dishonesty about the hacking, and that is still this case. It's kind of, that's why, wrapping it all up, the refrain from my learned friends is same case, and that's just completely wrong. It's an incomplete summary of the case that we run in the set-aside, which pays no heed to the fact that it attacks the evidence on RAKIA's claims themselves. And the whole point is that before the Court of Appeal, what the Court of Appeal was faced with and what it analysed the position as being was one in which there was what it called a purely collateral fraud. That is one which did not address the merits of RAKIA's claims, including, on this point, reliance. My friend Mr White sought to make some point about that. Paragraph 71 of the Court of Appeal judgment records that it approached the matter on the basis that it was not suggested, there was not a challenge to the finding of reliance by Mr Buchanan. And there now, under the set-aside claim, is a root and branch challenge to Mr Buchanan's reliance and a root and branch case against him to say that he has been dishonest from top to bottom. Well, Justice Newey then put to Mr Pilbrow, well, this is page 28 of today's transcript and again at page 31. Well, but just what if there was a smoking gun? And my own friend Mr. Pulbrow accepted that in that event, it's correct, this challenge could be brought. And he sought to say, well, there's all a spectrum, and this case is not that. But what he did by doing that was to concede exactly the principle, which is that the Court of Appeal did not foreclose and could not in law have foreclosed and should not be read to have foreclosed an application to set aside the judgment of Deputy Judge Lennon on the grounds that it was procured by fraud. He referred in the same context to the reference in the speech of Lord Sumption in Takar to decisive new evidence. Well, what is the decisive new evidence? It is evidence that is material, that can meet the test in RBS and Highland, which in this case it has already been found and is not appealed. The evidence does meet. So that by way of jumping ahead of what I was going to do. I said there was an overview. Obviously, the permission application was launched after the discovery of the project updates, over 1,000 pages of project updates, accessed first or became available first to Mr Azima in late June 2022, revealing a raft of evidence, not only as to the hacking, but also as to RAKIA's claims, and making it obvious, indeed we would say, essentially indisputable, that at least the ruler and Mr Gerrard and Mr Buchanan were pervasively dishonest throughout the first trial. That those documents were not disclosed, but it's not just that they were not disclosed. Even if they had been destroyed pursuant to a security protocol, the ruler and Mr Gerrard and Mr Buchanan gave pervasively dishonest evidence about the scope of that investigation, about its targets, and about what it dealt with. Their case was, this is nothing about Mr Azima. He was never investigated at all. And that is really remarkable. The set-aside claim that we seek to bring is brought, of course, only against RAKIA. Only RAKIA was party to the original judgment. None of the appellants will be twice vexed if it goes to trial, and it will not result in the substantial use of additional court resources so as to call the court to be careful about the finality principle and whether it is appropriate that such additional resources be used. Now, my own friend Mr Macefield, yesterday at page 16 of the transcript, said, well, actually, it will, because the trial estimate has been increased in order to deal with it. And of course he is right, the trial estimate is now 8 to 10 weeks, whereas previously it was 8 weeks. But it is relevant to...
originally?
I beg your pardon, I didn't hear that.
What was the trial estimate originally?
8 weeks.
8 weeks.
Yes.
And what is it now?
8 to 10. So it's essentially a make-weight point anyway when you look at it in the scale of things. But in fact what happened is that, and it is important in regard to the attack on his Lordship Mr Justice Green in that regard, is that it was essentially common ground when the permission application was argued before his Lordship Mr Justice Green that all of this material would have to be dealt with on the hacking claim in any event, and therefore that there would not be a substantial lengthening of the trial, or material lengthening of the trial. There was, as a matter of prudence, an attempt to just make sure that 10 weeks was available in case it be necessary. And what has then really led to that 10 weeks being taken is that in the event, your Lordships will appreciate that the pleadings in the set-aside claim have continued pending this appeal, so that the timetable is not disrupted. And so amended defences responding to the set-aside claim have been filed. And those defences actually include, in Schedule 1 to Dechert's defence, which is, I'll just give you the reference, it's Core Bundle tab 20, page 130, an effective relitigation of RAKIA's claims by Dechert against Mr Azima. Slightly odd proposition which was debated in the CMC, but they've been permitted to do that. And that has meant that whereas in the set-aside claim, the only question would have been materiality, if it proceeds to trial, Miller and Friends will also seek to persuade the court of the underlying merits of the claims against Mr Azima, and he, of course, will have to call evidence in response to that. And that's what's really led to the increase. So the increase is a result of a tactical stratagem of the appellants and not of the fact of the set-aside claim in itself.
Can I just understand that?
Yes.
Suppose that you lose here. Why won't that issue fall away anyway? It won't require any further investigation, because you just look at the judge's judgment.
I wasn't suggesting anything different in what I just said, is the first point. That's exactly the argument that they make.
Yes.
And that's the privies point. And of course, there is a question as to quite how far Hendon and Henderson would apply or issue estoppel as applied to privies in those circumstances. But their contention will be that you just look at the judgment. The point I was making at the moment was a much narrower point, which was merely that the set-aside qua set-aside hasn't itself given rise to any increase in the trial estimate, and certainly not a material one. And that we do say the twice vexed principle is in those circumstances the far weightier.
The court has to look at the matter in the round, Mr.
I agree.
Which includes whatever the defences are to the new, as it were, the new claim. You may be right, it's a tactical stratagem in one sense, but I can quite see why, in the light of the submissions we've heard so far, it will be said by the additional defendants, well, you can go on saying as many times as you like that you introduced the buyers to the hotel, but you can't get round the fact that the judge found that you were bribing Dr. Massad. So the conspiracy claim should stand. That's their argument.
That is their argument, and I wasn't suggesting it wasn't their argument. So as to what the judge found, can I take you to core bundle tab 10?
Hang on. Just clear the decks a moment.
Yes, and it's MACB for the transcriber. Everything is in MACB tab 10.
Why has everything got MA in front of it? I did wonder.
There have been so many hearings
March appeal.
that they all have prefixes.
March appeal.
So it's March appeal, whereas the CMC was March hearing bundle. The permission was October hearing bundle.
Okay.
And various similar variants behind that, Magnum having been deployed since the early stages of this litigation.
For your benefit rather than ours.
It does mean if you were to log in to the Magnum system, what you would see when you opened up the documents folder is a long list of bundles, of which this one would feature quite far down as MACB.
Okay, so we're looking at the judgment of the learned judge.
So we are. And if we can just run through it, I just want to skip through it but identify the paragraphs as I go. The core points really paragraph 21 on page 7, and in the paragraphs that follow, identifying the principles from Takar and Gracefield and Royal Bank of Scotland versus Highland Partners, and concluding in paragraph 26 over the page, that there are two elements to be satisfied, that's the fraud condition and the materiality condition. Paragraph 27, making plain that nobody suggested and nobody suggests that Mr Azima does not have a real prospect of success in establishing the fraud condition. So that it must be assumed for purposes of this appeal that RAKIA acted with conscious and deliberate dishonesty at trial, which is the relevant test. Then paragraph 28 and following, turning to the materiality condition and its requirements, the requirement that it is an operative cause, and that being sometimes voiced as, and one sees this in Highland, as being evidence that would have entirely changed the way in which the first court approached and came to its decision. and His Lordship Mr Justice Green then deals with, there have been two subsequent High Court decisions which have considered whether those are two different tests, the one deriving from Highland, the other deriving from some other appellate authority in Hamilton and Selecki Poor versus Palmer, a judgment to which my Lord the Chancellor was party. And those judgments ultimately say, well, it doesn't really make a difference. They're just different ways of expressing the same point. And His Lordship Mr Justice Green accepts that he will approach it in that way for purposes of this case. That, of course, meaning that it is right to say that materiality, having been established, having been found to be established by His Lordship Mr Justice Green, effectively, the way one should look at this is that there is evidence which would have entirely changed the way in which Deputy Judge Lennon would have approached and come to its decision. Then paragraphs, a point about burden of proof, which needn't detain us, paragraphs 34 and following, dealing with the issue as here, where in some sense the relevant allegation of fraud that underpins the procurement by fraud proposition had been raised at the original trial, and that's debating then the different positions of Lord Kerr and Lord Sumption in Takar, and His Lordship Mr Justice Green appears simply to approach it on the basis that, well, there may be a discretion to be exercised, and in that sense, of course, he does ultimately exercise that discretion. Then an analysis of the first judgment, which I'll skip over for now, and all the way down to paragraph 101, dealing, well, it's from paragraph 88 to 101, dealing with a jurisdiction argument. So my learned friend sought to argue that for at least three reasons, the judge hearing the remitted a hacking counterclaim simply had no jurisdiction to hear this challenge.
Proceed on appeal, so we don't need to worry about that.
And that point is not challenged on appeal, which is the 5230 point. And then paragraph 125 at the end of the abuse of process section, concluding that it would not amount to abusive relitigation of issues and evidence that have been determined on the merits in the CA judgment or in the refusal of the Supreme Court to grant permission to appeal, and no election having been made. That's the Cauchy point. Paragraph 130, that also meaning that there's not an impermissible collateral attack on the judgment, and paragraph 147, after going through my learned friend Mr. White's arguments contesting materiality, concluding that Mr. Azima plainly meets the relevant standard, which for the permission judgment and before the lordships is real prospect of success on materiality, and finding that that has been that threshold has been plainly crossed. So no doubt about it in the judge's mind. Now the limits of the appeal then, going back to my intervention yesterday when I thought that had been lost, but your lordships made clear it had not, is the only attack is abuse of process or collateral attack on the Court of Appeal's first judgment. And what that means is this appeal falls to be decided, or falls to be addressed, on the basis that the application for permission was procedurally and jurisdictionally proper. The new evidence must be assumed to show conscious and deliberate dishonesty. The new evidence must be assumed to be material so as to have entirely changed, or would have entirely changed the way in which the first court approached and came to its decision, and that insofar as any question of discretion is involved, the judge has exercised that discretion, and his discretion has not itself been challenged. As to the test on appeal, largely accepted by my learned friend Mr Pilbrow. We start from Johnson and Gore Wood. It's a broad merits-based judgment if you're considering abuse of process. And that leads to the points that we make in paragraph 41 of our skeleton, which I understood Mr Pilbrow to accept. It would be necessary for the appellants to show that the judge's decision was plainly wrong. That's under Harbour Castle. Considerable weight being given to the views of the judge. That's under Michael Wilson versus Sinclair. And under my Lord the Chancellor's judgment in Causa and Causa, which is in the authorities bundle of tab 15, I won't turn it up, that the Court of Appeal will not interfere unless the judge has failed to take into account something which he should have taken into account, or has taken into account something which he ought not to have taken into account. Now, my friend Mr Pilbrow said he accepts that, but argues that if they are right, well, all of those tests are met. And can I just say, by way of introduction in that regard, that if your lordships were to find that the objective meaning of the Court of Appeal's judgment, despite it not saying so expressly, is forever and a day to exclude the jurisdiction to have the judgment set aside on the basis it was procured by fraud, then of course it would be right that the judge would be plainly wrong. So
Well, that's in a sense, given the narrowness of the ground of appeal, as you just pointed out, which is in effect abuse of process through collateral attack, the whole thrust of that argument is the argument that this additional counterclaim is precluded by the order, by the judgment and order of the Court of Appeal first time round.
well, that's
So
fine.
the whole thing turns on what the Court of Appeal decided and what it meant. And if you're right, then the judge was plainly right. If you're wrong, the judge was plainly wrong.
Yes, on that point, and I completely agree with that, so far as it goes.
And there isn't some. It's not said, for example, that the judge misapplied the relevant law, because that
No.
would need to be a separate ground of appeal.
No,
which it isn't.
but that quite so. But what the learned friends do with respect is seek to raise a range of more granular arguments about the way in which the judge evaluated what had happened in the appeal and so on, and the evidence. And as to those, well, there the position is quite different. My learned friend Mr Pilbrow sought to say, well, they would show irrelevant factors or relevant factors not taken into account. Well, they don't. The right analysis is that His Lordship Mr Justice Green plainly, carefully considered all of the arguments now advanced and reasoned his way through them. He did not take irrelevant considerations into account, and he did not fail to take any relevant consideration into account. And so the only question is the macro question, not the granular question. It's the macro question. Can it really be that the Court of Appeal was intending to preclude this entire jurisdiction forever and a day? May I, it may help, but if I briefly set out what we say the right analysis is. I do this with some hesitation because it's an analysis I'm going to develop. And what tends to happen to counsel when you try to do this by way of introduction is that the questions then come before you've had an opportunity to develop the arguments. But taking that risk, but hoping that it won't eventuate, can I summarize it? And then as I say, I will develop it. So first point is that the question before the judge was, did we have a reasonable prospect of success of establishing the fraud condition and the materiality condition? Second point, under Dechert, the right analysis is that in a claim to set aside a judgment procured by fraud, it either does not matter or if it matters, only raises a question of discretion, that the argument, not the case, but the argument that as to there having been a fraud had been raised before. And as one can see entirely clearly from his lordship, from Lord Sumption's speech, the controls on this are the Highland criteria, that is materiality and fraud. The court places a high price on the integrity, in the broadest sense, of the judicial process. And therefore, as in other circumstances, the fact of fraud which meets those criteria and which procured a judgment is a very serious thing. And if those criteria are satisfied, well then that is the case. And then thirdly, as I've already said, the fundamental question is as to the objective interpretation of the Court of Appeal's judgment. And we say that once you've got fraud conceded for appellate purposes, materiality conceded for appellate purposes, really there ought not to be an argument here at all. The nub of my learned friend's argument appears to amount to the following 6 propositions, and I'll return to them at the end of my submissions. That Deputy Judge Lennon considered the evidence of fraud and found that the underlying liability was established, and my learned friend Mr Macefield yesterday, page 7, put it as being in effect indisputable. That the new evidence does not include anything materially or qualitatively different. He made that point in order to say, in order to justify the conclusion, that that is why the Court of Appeal, in paragraph 61 and 62, I think it is, found that the hacking was only collateral. And on that basis made the submission that that in turn is a reason why the objective interpretation of the judgment should be that the Court of Appeal did intend to foreclose the procurement by fraud jurisdiction forever and a day. And that Mr Azima's case is simply the same as that previously advanced, which the Court of Appeal rejected. And we suggest, frankly, that all 6 of those points are wrong, and I will seek to expose the fact that they are wrong. I may note straight away that it ignores what the grounds of appeal were. It ignores the constraints upon appeals on questions of fact, which is an issue I'm going to come back to and is of some importance. Indeed, reliance is placed by all 3 of my learned friends on Mr Azima in the Court of Appeal not having challenged particular points. He couldn't challenge factual points because this court has said in Fage and Shabani that that is not an appellate question. So it's completely the wrong inquiry. But most importantly, those points of theirs ignore the fact that there is this huge volume of new evidence which has been found to be material, not only to the hacking claim, but also to RAKIA's claims. And pushed on this point, in response to questions from Lord Justice Newey, pages 136 to 138 of yesterday's transcript. My friend Mr Macefield conceded that, well, it might be different if the new evidence was, as he put it, qualitatively different. And that is also the argument set up in paragraph 39 of his skeleton argument. Now, as to that, the first point is it's entirely clear that the new evidence is qualitatively different, and I'll go through it in some detail. But the refrain that this is Mr Azima having another go at what he did in the Court of Appeal really does deserve a little bit of question. In the Court of Appeal, he had an inferential case, circumstantial evidence case as to dishonesty, some new evidence about phishing emails, which he couldn't tie to any result. He could merely say, here are some phishing emails which seem to have been sent to Mr. Azima and some other associates of Dr. Assad. And then there was the indirect evidence of an investigator as to admissions by Cyberroot, an Indian hacking firm, as to involvement in the hacking, giving rise to the problem identified by my learned friend Mr. White this morning, that that was only in 2016 and was therefore a different case, as the Court of Appeal noted in paragraph 134. But taking all of that in, the submission as to fraud and pervasive dishonesty was only advanced in the context of the hacking and its cover-up. There was no material, none at all, to drive that through to evidence material, evidentiary material, directly relevant to RAKIA's claims themselves. Of course, points about credibility were made, but no direct evidence going to the hacking claims. And that's the contrast with the position now. On any view, a different case qualitatively and quantitatively. It is simply misleading to describe the new evidence, as my learned friends do, as additional detail. And it's, for your Lordship's reference, the new evidence is considered by His Lordship Mr. Justice Green in the judgment, or bundle tab 10, page 21, paragraph 78 to 87, and page 33, paragraphs 132 to 141.
Sorry, give us those references again.
Yes, of course. Core bundle tab 10, page 21,
Yeah.
paragraph 78 to 87,
78.
8, the new evidence, the heading, the new evidence, it runs through to 87. And then secondly, page 21, so it deals with the jurisdiction arguments and the other arguments, and returns to materiality at page 33, paragraphs 132 to 141, and then some concluding paragraphs through to 147. So it deals with the new evidence there. And the fact that once that analysis is not challenged, which it is not, and once that point is taken seriously, this is plainly, in Dechert's own terms, a proper case for permission. Now there is a connected point, which is that the thrust of your learned friend Mr. Macefield's argument was that anything which comes from this new evidence was, in effect, raised in substance before the Court of Appeal, and the Court of Appeal determined that issues of that same kind were not material. That's his fought and lost point, as he described it. Now, we obviously say that on any fair comparison, and I will develop this, between what was before the Court of Appeal and what is now available, that is simply wrong. But even were it right, it would be an argument to say that the new evidence is not material for that reason. And that is the very argument that is outside the scope of this appeal. Fifth introductory point before turning to the law. The essential argument before you is that Mr. Azima was found to be a fraudster, and that you should approach this appeal on the basis that he is a fraudster. Now, of course, that's a slightly remarkable proposition the moment you think about it, because the whole point of the claim to set aside the judgment is that we don't accept any of those findings. He was constrained in his first appeal by Fage and Shabani. It is now entirely clear, whatever the position was before, that there was a massive deception including as to the merits, and including as to Mr. Gerrard's perjury school at Hotel Museg in Switzerland, training witnesses to give dishonest evidence.
But how far does the new evidence really cast doubt on Mr Azima's fraud as opposed to reliance?
Well, I don't actually accept that one can say fraud as opposed to reliance, but
Well, there's
I
a
understand the
distinction
point as to
between
the
fraud and actionable
misrepresentation as distinct from reliance. I'm going to go through the materiality at greater length, but can I say this? When you analyse the findings and you go through what Deputy Judge Lennon, his lordship Deputy Judge Lennon found.
Well, there are two strands to this, aren't there? I mean, it's a point really my Lord's just raised with you. Obviously, there are misrep claims where the case was put that there had been reliance by Mr Buchanan specifically and by the ruler through him. And you say, on the basis of the new material, well, first of all, they knew exactly what Mr Azima was doing, and therefore there can't have been reliance. That's one, and I understand that point, that's one point, but there was also, the judge also found that there had been, in effect, that the referral agreement was a sham, was created after the event and backdated, and that there'd been bribery of Dr Massad. Now that's got nothing to do with reliance at all. Are you saying that the new evidence you've got enables you to challenge that part of the case?
Absolutely.
Well, we'll need some convincing.
Absolutely. Well, let me take it. Let me take it straight away.
Well, take it in your own time, Mr. Boone. Don't go out of sequence.
Well,
You get confused.
may I just make these points? I won't get confused, but may
Well, I know we might get confused.
may I just make these points? The finding that there was a bribe is ultimately based on the finding that there was a sham referral agreement and the absence of the introduction, there therefore having been no reason for the payment to Mr Azima. And that on that basis then rejecting Mr Azima's evidence as to the money that he paid to Dr Massad having been in regard to an aircraft, and B, having been repaid as it was. No dispute that it was repaid. All of these are analyses which are built from building blocks, which start from the introduction of, and we say there is massive evidence now to support the introduction. They start from the ruler's evidence, which was accepted by Deputy Judge Lennon, that he had not known about the payment to Mr Azima, whereas Mr Azima's case was he had expressly orally approved it. The material now shows the ruler to have been dishonest from top to bottom and to have commissioned unlawful investigation, and that makes the safety of that conclusion entirely in question. As to the sham agreement, the material shows that from August 2015, that's a year in advance of the proceedings and a year in advance of the release of the material on the contrived BitTorrents onto the internet, from a year before, the investigators had managed to get their hands on a copy of the referral agreement and kept referring to it in the project update reports. And in those reports, they react to feedback received as to things that they should pursue or not pursue, and the like, further evidence, further instructions given to them, etc. And yet, never a suggestion do you get that someone on the receiving end of the investigative reports is saying, but that agreement, we didn't conclude that agreement. That's not right. the idea that that evidence is not material, we say is fanciful. It plainly shows that the basis for the conclusion that it was a sham is a very questionable one, and one which the set-aside claim challenges. Can I also make this point? The question before this court is not what will be the outcome when the set-aside claims, or if the set-aside claims are heard. Still less is it what will the right conclusion be, taking the points on the documents that were made against Mr Azima, but putting them into the pot of all of the evidence now available, determining whether the claims are good or bad. That's not for today. The only question is, does Mr Azima have a real prospect of success, of establishing that case? And that is a very low threshold. So I will return to materiality in detail, but I wanted to that extent to respond to your Lordship's question. Can I turn then to the law, and I can make a little bit of progress before the lunch adjournment. As I said, I'll leave Koshi to the end. So key points on the law that are not in dispute are: setting aside for fraud is an independent cause of action. It's not necessary to show that the new evidence could not, with the exercise of reasonable diligence, have been discovered in or before the first trial and or the appeal. The claim lies even where an allegation of fraud had been raised before. May I ask you to note these references to the judgments of Lord Kerr and Lord Sumption, including Lord Kerr's approval of Lord Justice Newey's decision below in that case. Lord Kerr, paragraph 46 and 52 and 53 and 55, and Lord Sumption at 60, 63, 64 and 66 to 67. And then, of course, you have the two conditions, the materiality and fraud conditions. Now, a little bit more detail about Takar. First point, rather understated by my friends, that both Lord Kerr and Lord Sumption, it's true, obiter dicta, it's true. Both carry the support of another three members of the court, and therefore reflect majority positions. In the skeleton, it's a little bit less orally. My learned friend sought to make something of Lord Briggs, and in particular, in his speech, his explanation at paragraph 68, that this is about the outcome of a bare-knuckle fight between finality and fraud, and the effect of fraud. But it is important then to have regard to what Lord Briggs's difference with Lord Kerr and Lord Sumption was. And his difference was only that he would have preferred the law to be, I think that was his expression, preferred the law to be, although I accept it's all over to, but he would have preferred the law to be that there is not a bright line divide between fraud and non-fraud cases in regard to the reasonable diligence requirement. Because he made the point, there are scales of fraud and there are scales of lack of diligence, and therefore that it all ought to feed in together to some slightly more fluid analysis. But of course, let's stand back to this case. There is no suggestion, and there could not be any suggestion, that the new evidence we rely on in this case could, with the exercise of reasonable care and diligence, have been found before. Something learned friends never expressly stated, sort of suggesting, well, it's the same case, you could have raised all of this before, it's effectively the same arguments. This is material that was dishonestly hidden by RAKIA and Mr Gerrard and Mr Buchannan. So that if one were to take Lord Bridges' approach, would have come to the same result in the Dechert case, and we say he would come to the same result in this case. The only point on which he was differentiating being one which doesn't arise in this case. And if I can ask you to have regard in his speech to paragraphs 70,
Just a moment.
82, I beg your pardon.
Just a moment.
So if you're just opening it, that'll be Authorities Bundle, tab 10. No,
Yep, it's tab 10.
it is tab 10.
Sorry, which paragraph of Lord Briggs?
I wanted you to have regard in particular against that background. 68 you've already been referred to, and
Yeah.
then to pick up 70. 82, those are for the circumstances in which reasonable diligence might matter. And then 85 to 6, in which, in effect, he brings the preceding discussion together. So I say, there is nothing in his approach to advantage my learned friend's position in this appeal. And then as to Lady Arden,
Well, this 82 is the point about denying foolish victims who've been deceived by a knave. But his point in paragraph 70 is a much more fundamental point, which in a sense is the point you just made, where it's as it were, a deep-seated, sophisticated fraud,
yes,
which has been concealed. There's no point saying, well, what about due diligence? Because no amount of due diligence could have
well, exactly.
disclosed it. And
Exactly.
here, I mean, whether the failure to disclose the project reports was a mistake because they thought they'd been destroyed and they suddenly found copies, or whether they were deliberately held back, doesn't matter, because it's what's in them that matters.
What's in them and the evidence that was given by Mr Buchanan, Mr Gerrard and the ruler to Deputy Judge Lennon. And just to finish the point, I see you, my lord, looking at the clock. There's then also, of course, the speech of Lady Arden.
Yeah.
And really the same is true. The particular points to which I would direct you are in paragraphs 92, 94 and 101. And that will take me to the point of Lord Justice Newey's question to Mr Pilbrow of whether it is his case that either Lord Kerr or Lord Sumption are wrong, but I'll pick that up if that's a suitable moment after the lunch dinner.
Yeah. Right. 2 o'clock.
Thank
you.
All rise.